Dear students, welcome to Learn to Live. In this video, we'll be discussing about obligation. Obligation is an undertaking to do or not to do a certain act. It is also called vinculum juris. It is defined as a legal tie which imposes upon a definite person or persons the necessity of doing or abstaining from doing a definite act or acts. In other words, obligation is the legal duty to do or to abstain from doing something. So, an obligation binds on two or more individuals. It may relate to social or legal matters. Essentials of obligation. 1. There must be two parties. 2. It must relate to definite act or acts. 3. It must relate to legal matters but not to social matters. Obligations may have their sources in agreement or not. Obligations may arise even without any agreement. Obligations which do not have their source in agreements are not contracts. So, obligations arising from torts, quasi contract, and judgments of courts cannot be regarded as contracts. For example, obligation to maintain wife and children does not arise out of contract. Obligation to observe the provisions of the various acts also does not arise out of contract. Only obligations created by agreements are enforceable in a court of law since they are contractual in nature. A contract is an obligation, but all obligations may not be contracts. Law of contract is the law of those agreements which create obligations and of those obligations which they source in agreement. Students, this is the end of the section. Please share, like, comment, and subscribe. Make sure you press the bell icon for latest updates.